So, the people who are seriously ambitious on a constitutional amendment, they have clearly not slept in peace
Oh,
last
no.
night. Or maybe they did. We don't know. Because others who also had serious ambition on stopping that reggae had gone to court with several cases. David Day, Wajiroge Konyo, Cherochitsei, and two others had gone to court seeking to block amendment of key sections of the Constitution, saying these ones are what would constitute the basics of this Constitution. Others, Kenya National Union of Nurses, had gone to stop the BBI, saying their proposal was not factored in. The Third Way Alliance had gone to court arguing that BBI is a government-led initiative and therefore cannot be subjected to a referendum. Makueni Governor Professor Kivutha Kibwana had gone to court wanting the court to find that government cannot initiate a constitutional change process. Nandi and Kericho County Assemblies had gone to court seeking to the determination whether MCAs can amend the bill once it has been sent to them. In total, there had been 17 issues that the court was now asked to determine. 17 of them. The 500-page, 6-hour judgment delivered by the 5 judges of the High Court yesterday had various orders. Some of the orders: 1, declaration made that civil procedures can be initiated against a sitting president or person performing functions of the president when they are still in office. 2, the president does not have authority under the Constitution to initiate changes to the Constitution, and that a constitutional amendment can only be initiated by Parliament through the Constitutional Article 256 or through popular initiative Article 257. BBI's task force and the steering committee established via this Gazette notice in 2020, published in a special legal issue of January 2020, was unconstitutional and unlawful. Being an illegal entity, it has therefore no capacity to initiate any action towards promoting constitutional changes. That process, culminating to the launch of the bill, was done unconstitutionally. Also, specific proposed amendments to the Constitution can be amended as separate and distinct referendum questions to the people. You cannot have 31 question for 72 amendments or 76. All those things, including, well, there was one prayer here that had been said. Now, if you find that the president acted outside his authority and what is permitted in the Constitution and the laws of Kenya, by initiating this process, by establishing the BBI task force, by giving them the mandate, by all, if you find that this whole process was wrong, can you tell us who's going to pay for this process? And can we therefore surcharge the president? The court, however, said the prayer for an order that Mr. Uhuru Muigai Kenyatta refunds the public funds used in the process is declined. So we still need to find out, so who pays them? All those things were declared. Now, there's are very many arguments that come out of here, including that IEBC does not have quorum. And the judges said does not have quorum, period. So, very many things that came out of this. What does it mean now going forward? If, assuming that it's taken to the Court of Appeal and the Court of Appeal agrees with the High Court, it's even taken to the Supreme Court, and the Supreme Court does not change much of what these 5 judges said yesterday. What does it mean? Even going forward, yes, okay, BBI is our. But even going forward, what does it mean? Let's talk to constitutional lawyer Waikwa Wanyoike, who has spoken to us before about this BBI process and giving us his views. He joins us again this morning. Good morning, Waikwa.
Good morning, Eric.
Welcome to the Situation Room, wherever you are in this morning. And even though I don't know whether you're a Muslim or not, but it's Happy Eid.
Happy Eid to you and to everyone.
Now, Waikwa, the headlines this morning are saying this is a bombshell. This has basically just gone and disrupted the juggernaut and all. What do you make of that ruling yesterday by the 5 judges?
I think the judges had fidelity to the Constitution in their mind. And, judges take an oath to protect and uphold the Constitution. We know that the Constitution itself has made the courts its custodian, and by making the courts its custodian, then that means it's made the judges its custodian. And so the judges just were asked questions. Remember, those 17 questions that they outlined are not questions they brought from home. These are questions that were asked of them by litigants. In fact, there were a bit more, but they consolidated the issues. And then all they needed to do is to look at the Constitution, to look at the law, and answer the questions as honestly as they could. And that is what they did. And in fact, even though people call this a bombshell, it's not, because all this was predictable. Even a very less seasoned lawyer, if they had been presented with these issues earlier, they would have been able to say, you can't do this thing, because they don't seem to be supported by the law. Obviously, the judges did a lot in terms of showing the justification through their research on why this was illegal and unconstitutional. But at the end of the day, the judges didn't say anything that is outside the law or outside the Constitution. They just did what they are required to do.
Okay, Waikwa, it seems that some of these things, just like you said, legally would be quite basic for somebody to then understand. And so it doesn't seem as though, from what you're saying, that this judgment was outside the scope of the unimaginable, right? So why would it be that going into something like this, somebody who should be seasoned, because I would only assume that the BBI team and committee and task force and everybody had been legally advised, why would they make what would be considered by some to be such a rookie mistake?
Thanks, Doko. Just because of at least a few things. One, arrogance, political arrogance. It's very clear this president has operated from a place of political arrogance that is above the law, that he will do whatever he wants to do, and people will just have to follow. He's not been following the court orders, even when he's told. So this is not uncharacteristic of him. And so he operates from a place that he can bully everyone, including bullying the law. And that's what he tried. And obviously he must have assumed that at the end of the day, he can bully the judges. And we've seen that happen. That's one. But the second one is just professional dishonesty. We are in a country where a lot of professionals do not have respect of their professional stature, because professional stature starts from a place of honesty. You have to have a sense of self-esteem that there is something that makes you a professional. When you are a lawyer, there is something that there is a meaning to you being a lawyer. And the starting point is somebody who can understand and appreciate and interpret the law and give the accurate interpretation. We've seen some of these lawyers make comments which are completely outlandish. And that tells you they're not being genuine, because even a first-year law student, just looking at the Constitution and being given the questions that were presented, they would tell you what the right answer is. So it's just lack of professional cadre and lack of professional self-respect when you give such advice, because I'm sure at some point the president was being told by a lawyer somewhere that this is okay and we can do it.
You know, I'm sure you'll hear others who will tell you, okay, you may call it professional dishonesty and all, but maybe those who are giving the advice to the president were actually also looking at the law, and that's their honest interpretation of the law. I'm looking at a very seasoned Attorney General, Amos Wako, who is a member of the BBI task force. when he was appointed into the BBI task force. And then you see 5 judges of the High Court saying the constitution, the appointment, the gazettement of this was completely unprocedural. You don't surely suppose that Amos Wako did not sit back and ask, but Mr. President, we can actually make this thing right at this point. He must have at some point believed that all due process has been followed.
Yeah, I'm sure Amos Wako knew this was all illegal. But who is Amos Wako? Amos Wako has been a legal chameleon for a very long time. That's how he survived during Moi's time, by obviously making sure that he conveniently advised on the law. And he has survived not just the Moi's regime, he survived Kibaki's regime. And now he's surviving the Uhuru's regime. Clearly, it is very difficult to convince me, because I know for sure Amos Wako is one of the most brilliant lawyers, but it's impossible to convince me that the kind of illegalities we've seen during his tenure as Attorney General, during his tenure during Kibaki's government, again, briefly as Attorney General, that he has not been knowing that certain things are illegal and not being candid about it. And obviously, he saw this as a political opportunity, maybe something that helps profile his political career, and so he took it. Remember, Amos Wako is the one who took the Bomas draft, went and mutilated it under Kibaki, and came up with a draft that was rejected by Kenyans at the 2005 referendum because of dishonesty. So that's the problem. When I talk about professionals not being candid, not caring too much about the respect as a professional, that's what I mean. And to some extent, Wako represents that.
One of the things that as a layman I've always find puzzling, at some level I understand it, but yet I still find it puzzling. You have all these levels of courts. You have a magistrate's court, a chief magistrate's court, then you have a high court, you have a court of appeal. All these stages of, should we say, of the justice system, of the judicial system, seems, in my mind as a layman, represent the understanding that there are issues that need to be decided or needs to be relooked at, and the issues of the law needs to perhaps be given a greater in-depth perspective than the ones presented. What am I saying? I'm saying this. Here we have a five-judge bench. Mm-hmm. Which one is it?
It always gets you CT.
Yes.
It's okay.
Bench.
There are 5 judges sitting on a bench
one.
deciding this thing.
Yes.
That's the easiest way to get this thing, okay? Now, they have made a ruling. But because there is a court of appeal, there is a likelihood that this matter could go to the court of appeal. Now, this is where it gets interesting. Every time something goes to the court of appeal and you hear a contrary view, the same process that was used in adducing and bringing out these issues that we now render as a bombshell are then also brought forward, and you're thinking, goodness gracious me, the law must be really complicated. Because they will quote statutes, they'll quote articles, they'll quote sections of the law.
The very same that the others quoted to start off with.
Constitution is the same one, but they will find, some will even tell you, actually, they use the wrong law in looking at this, and they'll bring something else. So, as a layman, where do you stand? Should I stand? Should I just sit back and continue reading and watching this thing unfold? Or should I understand that when there are 5 judges sitting down to determine an issue, that their ruling ought to be taken as sacrosanct? Or should I understand that given what the law and the Constitution is, the robust nature of it, this sort of debate is always an ongoing process?
CT, the first thing to begin with is that judges at the Court of Appeal and the Supreme Court are not necessarily better jurists than the 5 judges that we saw. Remember, the 5 judges that decided this case all qualify legally to be judges of the Supreme Court, not just the Court of Appeal. In fact, 2 of them are waiting or have been waiting to go to the Court of Appeal. So it's important for Kenyans to know that just because there might be divergent views by judges when this matter goes to Court of Appeal or the Supreme Court, it's not necessary because those judges in upper courts are necessarily better jurists. In fact, I have to say this. The bench you saw deliver this judgment constitutes some of our finest judges, not just in Kenya, anywhere. And in my practice, I don't just practice law in Kenya, I practice law elsewhere. So I know. And these are some of the judges, best judges anywhere. The second point. In a way, unfortunately, Court of Appeal has been one of our weakest link when it comes to constitutional jurisprudence, both in terms of articulation, but also in terms of showing courage. And we have quite a number of incidents we can refer to. And we hope that when this matter goes to the Court of Appeal, because everybody knows it's going to go to the Court of Appeal, and most likely Supreme Court, that the court takes this matter seriously. If you look at the judgment, which now has been supplied, any Kenyan will acknowledge that a lot of work went into this. These are judges with extremely good work ethics. These are people who are extremely brainy. These are people who have taken a lot of time. If you had the articulation, they would give about 5 reasons with maybe 5 alternatives. And unfortunately, sometimes we see our higher courts becoming a bit more casual with some of these things. So my second point is that I hope that the Court of Appeal and the Supreme Court takes things as seriously as they should. And the last point is that some of these issues are so basic that even though sometimes courts will engage in what we call legal sophistry, it's hard to engage in legal sophistry in these things or in answering some of these questions and still look like a serious court. Yes, there are some things that are a bit nuanced, and I'm sure when this matter goes up, you will see some divergent views. But there are things that are just so straightforward that if a court tries to engage in legal sophistry, even just your regular Kenyan who is following this, not with so much enthusiasm like some of us are, will say, wait a minute, there is a problem there. And I really hope Court of Appeal and Supreme Court live up to the calling that they are required by the Constitution, and they don't engage in political convenience in terms of the interpretation.
Okay. In this ruling, Waikwa, some of these things are quite heavy. Even as basic as they are, in terms of what will not be allowed, they are quite heavy. We're looking at a president lacking authority, according to this ruling. We're looking at an illegal entity having been set up to do something that would essentially amend the law that guides a country. We're looking at going against Chapter 6, which many have touted as one of the most crucial chapters in the Constitution. We're looking at an IEBC that had no quorum to be able to carry out verification of something like signatures. I mean, the list goes on and on and on. All of this came about as a result of several petitions that were then made to the court. I then am in a position where I shudder to think what then would have happened if these petitions had not been brought forward. Would we still be going through illegal processes according to this ruling, and nobody would have said anything about it? What would that have portended for the country?
And that's Duoko, that's the dilemma. We've seen what Parliament did. Parliament comes and says, oh, this thing is unconstitutional, but we'll pass it. And that is why I'm saying it's not like these people don't know what they're doing is unconstitutional. Some of those people involved are very, very senior lawyers, starting with the chair of JLAC, Muturi Kigano, very, very seasoned. People like Senator Omogeni, James Orengo is there, Otiendo Amolo, very, very seasoned. They come and tell us, oh, a lot of these are unconstitutional, but you know what? We'll pass them. So why are you passing them if they're unconstitutional? It just tells you the level of dishonesty. But while we acknowledge these are heavy issues, they are heavy mostly not because they are difficult or complex constitutional issues. They are just heavy because of the public interest and the public implication of the outcome. But none of these things are not obvious. Let's just take some examples. The finding that there is no legal framework to guide the process. The judges didn't say anything new. As far back as 2019, High Court had said the same thing and sent a memorandum to Parliament asking Parliament to enact a law to guide the referendum, following the Third Way Alliance popular initiative. Of course, Parliament gets that and just decides who is the court to listen to. Think about IBC. IBC, part of the problem is that it's not constitutionally constituted. If you go to the IEBC Act, it says that whenever there is a vacancy in the commission or in a commissioner's office of the IEBC, within 7 days of that vacancy, the president will start the process of recruitment. When did the IEBC commissioners resign? Is it 2 or 3 years back? What did the president do? Nothing. When did the president start this process? Just like a month ago. So what is not clear that was always illegal? Remember, the issue about IEBC quorum had already been determined in 2018. After the 2017 elections, remember Parliament changed the IEBC law to try and lower the numbers of members of IEBC who could constitute a quorum from 5 to 3. Katiba Institute went to court, and in April 2018, the court overturned those amendments and said, no, you can't do this because it means that a minority of IEBC members can actually rule over a majority by being sneaky, because all you need to do is have 3 members convene. They say we have a quorum while 4 members don't even know there is a meeting, and then they pass whatever they need to do. Again, this is how basic some of these issues are. Just a final example, the question about the IEBC own regulations that it came up with, which were found to be unconstitutional, actually say that once IEBC determines that at least the signatures amount to 1 million that support a popular initiative, it will post that information on its website. It will wait for 2 weeks so that if anybody wants to complain, they can complain. It can make the determination before it forwards the bill to the county assembly. Again, what did the IEBC do this time? It made the call that we have more than 1 million signatures. I think it was on a Wednesday or a Thursday, and the following Monday, it had sent the bill to county assembly. Like, how basic do you want us to be if you can't just follow even your own laws? And that's what the judges are asking. And this is what Kenyans need to know. Really, judges are just saying, follow the law. You have the law, follow the law. Where you don't have the law and you need the law, Parliament is there to enact the law. Let it do that. This Parliament has had over 10 years to pass a referendum law. It has failed to do that.
Eric Latif Nduoko, CT Muga, joining us on the line, is constitutional lawyer Waikwa Wanyoike. What's the impact of the ruling by the 5 judges of the High Court yesterday on this consolidated BBI petition? Now, Waikwa, when I look at this, and I'm now looking at the courts have basically said, and the Constitution also says, that even if we actually have a properly initiated popular initiative, it goes through the IEBC, there's a referendum law in place, and everything is set. It goes to the county assemblies. County assemblies cannot amend any part of such a bill. It goes to the Houses of Parliament. They cannot touch open any part of such a bill. Now, what happens if such an initiative actually contains clauses that would be deemed unconstitutional or that go against other parts of the Constitution? So, at what point then does that stop?
Two things about that. The first one is obviously county assemblies and parliament can make a notation about their concerns, like parliament did, that there are certain clauses that are unconstitutional. The only organ that has the power to determine whether ultimately whether a clause is constitutional or not is the court. And in fact, if you look at the draft referendum laws, Parliament has built in those bills a period within which, after everything goes through, citizens can go to court to challenge any unconstitutionality of a bill and bill to amend the Constitution that has been passed, so that the courts can interrogate and see whether, in fact, the proposals are unconstitutional, or any part of the proposals are unconstitutional, or they are not do not cohere with the Constitution. So that's the procedure. But we also miss another point. If IEBC, for example, had a concern, because even IEBC also has a constitutional mandate to make sure that whatever it's doing is not unconstitutional. It has a recourse. Remember, under Article 163, any state organ can go to the Supreme Court for an advisory on any matter that concerns county government. You can never talk about constitutional amendments if you're not talking about county governments, because even in the passage of the constitutional amendment, whether it's by popular initiative or otherwise, it has to go through Senate. So at that point, instead of having to take the country through a long process, IEBC can go to Supreme Court and say, can you look at this and tell us whether there is a problem and whether this should go ahead? County assemblies can do that. In fact, Kericho and Nadi tried to do that, and in fact, Supreme Court said, yes, you are rightly before us, but we want to give the High Court the chance to determine, and Parliament can do that, instead of just bulldozing things that are outrightly unconstitutional. But in any event, at the end of the line, the High Court can come in and determine whether a law is unconstitutional or not. So the Constitution has created sufficient safeguards.
Can I jump in and ask you, Waikwa? So, looking at the IEBC specifically, people like Eric have long said that politicians use the IEBC to be able to, dance to their particular whims. So, in this case, looking at IEBC has no quorum, is what the judgment was, and that to carry out its mandate and the referendum. I mean, it sounds like a very basic question, but if you as a commission know that you do not have quorum and that you cannot carry out a referendum, I mean, those things would be very clear to you as a commission. You know this. And then here you are being asked to carry out a particular duty. Why would you not then ask the question, what is being asked of me as a commission, number one? And I know that I don't have the wherewithal constitutionally and legally to carry this out. Why would I then as a commission go ahead with a process that was flawed from the onset?
Again, this goes back to professionalism. Because, again, Chebukati should have come out, alerted the president, I'm not sure whether he didn't, saying, look, this is what the law says. You should get us, or you should start the process of recruitment of new commissioners, because these are the dangers. Kihara Kariuki, the AG, that is his work. He should have alerted the president to that, and in fact push and say, look, this is what the law says. In other countries, somebody like Kihara Kariuki would have resigned by now, because when the court poses 17 questions, all of which you had said there's nothing wrong with them, and the court returns about 15 of them and says everything about these 15 is wrong, and you are the Attorney General, and you've been insisting that everything is right, what does that say about you? So it's again going back to our professionals doing the right thing. Remember, again, even if IBC, we know that the political elite frustrate this commission. Again, if IBC was frustrated at the political level, itself could go to court and ask, what are we supposed to do? So that actually it passes that obligation to somebody else who has the authority to actually put something on record that you tried to do this, and yet the political class was not cooperative. The problem is that these people, they want to be politically convenient so that they can please the political actors, while at the same time making all this rhetoric about their independence, about doing the right thing, when it's clear that they are not even doing the very basic. And again, I return to the question, why would IBC, when it said in its own regulations that things will take at least 2 weeks, at least, not within 2 weeks, then it just flouts a very basic thing. What else do you call that?
It's called survival, Waikwa. Like you said, looking at personal survival. I've got a question still on the IEBC. Now that the judges have said that this IEBC is not properly constituted, so what's the fate of all the work that the IEBC has done since 2018? The by-elections it has conducted, the other elections it has supervised, including elections of the Law Society of Kenya, elections of Law Society of Kenya to a representative to the Judicial Service Commission, judges and magistrates representative to the Judicial Service Commission, and others. What's the fate of that then?
It's important when Kenyans look at the judgment, or when they listen to the judges, they were very, very careful with the way they were using their language. So, for example, they were saying policy decisions of the IEBC. Why is that important as opposed to administrative functions of the IEBC? Is because their IEBC has sort of two parts to it. IEBC has the commissioners. The commissioners are the ones who have the power and obligation to deal with policy issues. And then IEBC has a secretariat, which is headed by the CEO, which does the administrative work. If you look at the decision that was made a while back about whether IEBC could conduct by-elections, the judge in that case said by-elections are just administrative things because really there is not much that commissioners are doing in terms of decision making. It's just putting things in motion. But there are certain things that cannot be done by anyone else other than the commissioners. And so that distinction is important. So it doesn't mean that everything that is being done at IEBC at the moment is illegal. And in fact, the orders of the court are very, very specific about BBI bill or a bill that is brought to them through popular initiative. So I think it's important for Kenyans to understand that. And the reason behind this is that the people who are entrusted to safeguard the independence of the commission are not your regular administrative staff at the IEBC, even though they have an obligation. It's the commissioners. The people who are actually constitutionally protected largely are the commissioners when it comes to independence. And the reason for that is because the Constitution knew that there will be very heavy decisions that will be taken, and you need to attach significant constitutional protection to the person taking those decisions, and those are the commissioners when we talk about the independence part of the commission. And this one is one of those.
Mr. Waikwa, I want to take, I want you to join me on a certain mental journey I want to take. Huh? When I look at the number of court rulings that this particular executive administration has ignored, outrightly ignored, I now look at the situation that we are in. The judges have made their pronouncements. They choose to ignore it. It goes wherever it wants to go, up to the Supreme Court, make their judgment. They continue to ignore it. Just like they ignored the advisory note that the Supreme Court gave regarding the dissolution of Parliament with regards to the gender rule. Now, if all these things happen, and we even go to a referendum, because that would be following in that trend of ignoring whatever ruling that the courts have arrived at, and on to an election, where will that take us from a legal perspective, a legal standpoint?
So they ignore, we go to a referendum.
Oh, yes.
People actually turn up in large numbers to participate in the referendum.
Yes.
And so people exercise their direct authority to pass or reject.
Or reject or whatever. Yes. Where will that put us?
You know, CT, they say even the biggest village bully meets his match one day. And we are getting there now. And I'll tell you what. If you actually look at how this judgment has come about, and what is now going to bite Uhuru Kenyatta and Raila Odinga and their supporters of BBI is actually a lot of what they've done in terms of ignoring court orders. As I said, they had been told to pass the law, they refused to pass the law. They were required to recruit the commissioners, they refused to recruit the commissioners. If you actually think about it, two of those judges who sat in that case, if the president had followed the law, they would be at the Court of Appeal. They wouldn't be sitting in that. They are still in the High Court because they've not been gazetted. So, again, at some point, even when you try to be so smart, things catch up with you. This time, it's actually a bit more complex for them. Because remember, and this is a point Kenyans should not lose, if this process has to yield anything for the political class, it's two things. One, an expanded executive and parliament. That's why they went, or they've been pushing this. And the second thing is the constituencies. Under the constitution, you cannot change the constituencies less than a year before the general elections and still use those constituencies. We are running out of time. So, and I can almost tell you, unless the Court of Appeal and the Supreme Court really do this in haste, if we just follow the usual processes in court, it's very unlikely this matter will be settled, either by the Court of Appeal or the Supreme Court before the end of the year. And we still have elections in August. Who is going to be pushing for a constitutional referendum next year when it's still very tentative, when you also have elections in August? Do you want to tell me Odinga now will abandon his presidency quest and campaign so that he can just keep pushing for a BBI bill?
There are those who are saying that, I'm sure you've come across those murmurs and schools of thought that, the election in 2022 can be pushed a bit further to 2023 or something like that. So we go to an election with these reforms having been in place and voted for by Kenyans in a referendum.
There's one thing that we can say it's constitutionally sure, and there's something we can say it's not constitutionally sure. The date of elections next year is firmly in the Constitution. Even BBI wasn't trying to change that date. So that date is set. Changing the Constitution until it has happened, until it's been fully cleared by the court if there is litigation, it's not happened. So even assuming that we can have a referendum in the next few months, it doesn't mean that the constitution has been changed. By the way, just because the court decided the matters yesterday, this is not the end of litigation. I'm sure you'll see new litigation being filed at the High Court about, for example, did the processes that Parliament used, were those constitutional? So for a politician to peg their lack on waiting for the constitution to be changed when the process is so tentative, I think it would be extremely ill-advised. Let's just also take the reality into account. How old is Raila Odinga? Do you want to support pushing elections by another 2 years, 3 years, and then very soon you are 80 and you want to be running for president when you are 80? If he has any best chances, it's 2022. I'm not even sure about that, but there are just certain things that logically don't add up.
They will not add up.
Even these people themselves will acknowledge.
Actually, Waikwa, you have a point when you're talking about logic, but then please remember you're talking about politicians. And the logic that the logic that politicians apply when making decisions are not the logic that you are applying in very reasonably and in this measured way explaining this situation. Because if they followed that sort of logic, even this discussion would have been, as you lawyers say, moot. Because what would have happened, they would have ensured
the right things
had been done, and so that we'll just be talking about what are the processes to follow, but they don't think like that.
I have a final question for you. There's this declaration number 7. A declaration is hereby made that Mr. Uhuru Muigai Kenyatta has contravened Chapter 6 of the Constitution, specifically Article 73, 1A1, by initiating and promoting a constitutional change process contrary to the provisions of the Constitution on amendment of the Constitution. What is the implication of this declaration? It talks about the president, talks about Chapter 6, and says clearly that the president has contravened Chapter 6 of the Constitution.
Maybe just one point about CT's comment there before I answer your question, Eric. Politicians are mostly driven by self-serving needs. And the good thing at least about politicians is they know how to change and feel unaccountable when they change their positions. I can almost tell you this, CT, if this matter waits until 2022, maybe late 2022 to get to the Supreme Court, some of the politicians and their lawyers who have been strongly arguing in support of BBI will be arguing the other way. But to Eric, the judges are supposed to look at what has happened and make a decision one way or the other whether they agree with the petitioner who has brought the petition. They looked at what the president had done. They found that he had acted outside the law. And then they went to Article 73. It's very clear in terms of use of public power and bringing disrepute into public office, and made that conclusion. One thing that Kenyans should know is that the responsibility of holding the president accountable for violating Chapter 6 is responsibility of Parliament. It's Parliament which is supposed to do that and determine sanctions. And this is not unique to Kenya. Just to give you an example, in South Africa, the court made similar findings against President Zuma. And actually, the matter ended up in their parliament in terms of consideration whether the president should be impeached. We have provisions about holding president account, and it's not just about impeachment. It's also about overall oversight. So what Kenyans should be demanding is for Parliament to require the president to explain whether or why he outrightly contravened the Constitution. But the judges were required to make that determination because the alternative was they've been asked a question, they are required to respond to a question. Their own analysis leads them to one conclusion, but then they end up making a different conclusion. That is what we call legal sophistry, which judges are not supposed to engage in.
Waikwa, thank you very much for joining us this morning. Waikwa Wanyoike is a constitutional lawyer. We've been talking about the impact of yesterday's judgment by the 5 judges of the High Court with regards to the BBI process. Have a lovely day, Waikwa. We'll be getting in touch with you again soon.
Thank you. Thank you, Eric. Thanks.